I'm Ben Meiselas from Legal AF, joined by your favorite co-host, Michael Popok. We are here to discuss another powerful motion. They're coming fast and furious by Fulton County District Attorney Fani Willis. This is in response to an emergency-styled motion. It's framed as Mark Meadows' emergency motion for immediate removal and request for an injunction. The federal judge in the Northern District of Georgia who received this case when it was removed by Mark Meadows, Judge Steve Jones, gave Fulton County District Attorney Fani Willis a deadline to file on Wednesday, which she met. But the basic procedural history here, right, is you've got the indictment in Fulton County for RICO crimes against 19 defendants, including Donald Trump. That gets filed. The grand jury votes on it on Monday, August 14th. The next day, on Tuesday, August 15th, Mark Meadows files a notice of removal. Mark Meadows, Donald Trump's co-defendant and former chief of staff. And he states that he satisfies the three prongs for removal, that he is a federal official, that he was acting under color of law, and three, that he has credible federal defenses. Now, what a judge could do is give summary remand and just say, reject the removal as out of hand, or request an evidentiary hearing take place. Judge Jones requested an evidentiary hearing that's scheduled to take place on August 28th. Then, over the weekend, Mark Meadows filed a motion to dismiss, asserting the Supremacy Clause, the First Amendment, and the 14th Amendment before the federal court even agreed to have jurisdiction in the first place. And then, as the deadline has approached for Mark Meadows, like all of the co-defendants, including Donald Trump, to surrender with a deadline at noon on Friday, August 25th, Meadows, again, like filing. And then he filed this emergency motion for immediate removal and request for an injunction, requesting that Judge Jones not hold an evidentiary hearing, not allow Fulton County District Attorney Fani Willis to even, I guess, respond to the removal and to put on witnesses. And by the way, she's gathering witnesses to have this evidentiary hearing on August 28th, and to intervene because Meadows believes it will cause him irreparable harm if he has to surrender and be booked. And otherwise, if he doesn't surrender, Fulton County District Attorney Fani Willis said, okay, we're going to put a warrant out for his arrest and he's going to get arrested. So Meadows brought this emergency motion, and now Fulton County District Attorney Fani Willis filed her response. Michael Popok talked to us about, I think it was a brilliant response that she gave.
Yeah, it's brilliant. Meadows is he's the stalking horse here, apparently, for the other 19 or the small handful that think they have some sort of argument that they can run across the street to the federal court in an effort to have a federal judge decide on whether Supremacy Clause immunity would prevent the prosecution from going forward. That issue, whether it applies or not, could be easily decided by Judge McAfee in the Fulton County Courthouse. It doesn't have to be a federal judge to make that decision, but they want to get over to federal court. I don't know why they don't like McAfee, even though he's a new judge. They think they're doing great in front of a brand new judge down in Florida with Judge Cannon. He's a Federalist Society guy too. I don't know why they're running away from McAfee. And now they've run across the street, but it's a random selected judge, and the random selected judge in the Northern District of Georgia that sits in Atlanta directly around the corner from the Fulton County Courthouse is a Obama appointee. And he is now going to be responsible for all of anybody that wants to bring up an issue on removal, i.e., I don't want to be in state court. I want to take my prosecutor and my Georgia state crimes against me, and I want to have it tried across the street in front of a federal judge because I may want to take a federal appeal to the 11th Circuit and then to the U.S. Supreme Court. To paraphrase something I heard recently, for Judge Jones, this is now his circus and his monkeys, and all of them are going to have to be in front of him. There's not going to be any judge shopping or looking around for a better judge like one of the 4 Trump-appointed judges that happen to sit in the Northern District of Georgia, they are stuck with Judge Jones. Now, Judge Jones is as methodical and sober and judicious as we've come to expect from somebody like Judge Chutkan in D.C. And already, in response to this flurry of filings, it looks like every day, every hour, as part of their master strategy, they are filing to get papers in front of them. The first paper was what's called the notice of removal that you mentioned before, Ben, which they filed, which everybody files when they want to get out of state court and go to federal court. But here there's narrow grounds for people that claim that they were federal officers, meaning that they were in the administration, in the case of Mark Meadows, chief of staff. And you cited, we cited before the statute that relates to that. And you got to show federal officer doing stuff within the color of his office or her office that's now been implicated by something else in this, let's say, criminal prosecution, and that you have an arguable federal defense. Federal defense here would be the sovereign or the supremacy clause immunity. But all that can be decided and hashed out by Judge McAfee, who's moving his case right along at the velocity at which Judge McAfee in Fulton County is issuing bond conditions, issuing restrictions on people without even having a hearing, issuing bond amounts, setting the next date for hearing without hearing from one of them. They haven't even been arrested and arraigned yet. Shows you the major difference that you and I always talked about on Legal AF between state court process and federal process. They are as if they are not separated at birth. They are as if they were two entirely different worlds, and that's the world that these people like Mark Meadows want to get out of. We don't want to be in fast-paced, high-velocity, don't have hearings, where we can throw monkey wrenches in. We want to go to federal court where we could screw things up. And so Judge Jones has said to Meadows, I'll take a look at all your papers. In fact, I'm going to give you an evidentiary hearing on Monday, the 28th. And I'm not pre-deciding whether you have the right to removal or whether your supremacy clause immunity, i.e. I was a federal officer and I'm under the supremacy clause of the feds, and you can't prosecute me for doing my job as a federal officer, even in a criminal prosecution. I'll sort all that out at another time. I'll see you on Monday. And of course, that wasn't good enough for Meadows, because his arrest will be on Friday, will be in 2 days, which is before Monday's hearing. And the judge knew that. The judge knew, it's implicit within his order, that I'm not issuing anything to stop the criminal case in state court. One, he can't. Under a body of law that you and I referred to or the jurisprudence that we learned in law school, called the Younger abstention doctrine, based on a case from the 1970s, it says right on its face, the doctrine stands for the proposition that federal courts cannot, except in rare exceptions, and I'll talk about that in a second, they can't stop or enjoin a state prosecution. Right? Federal courts are for federal crimes and federal things. State courts are for state crimes and state things. And you're not supposed to interfere just because you want to go run across the street and ask daddy for help over at the federal court. And that doctrine says, unless there's bad faith in the prosecution or the way you're being treated, which there isn't, our hands are tied. That's all going to be decided on Monday. Boxing streaming services, that exercise app to show your friends you biked 20 miles in the rain, and your hometown newspaper for that one homecoming game score. There's subscriptions for everything these days, and sometimes it feels impossible to keep tabs on what you're paying for every month. That's why I'm such a huge fan of Rocket Money. Rocket Money is a personal finance app that finds and cancels your unwanted subscriptions, monitors your spending, and helps you lower your bills all in one place. Most people think they're spending $80 on their subscriptions, when in reality, the number is closer to $200. When you're signed up for so many things, like streaming services you used to watch one show with, or free trials for delivery you don't use, it's so easy to lose track of what you're paying for. With Rocket Money, you can easily cancel the ones you don't want with just the press of a button. No more long hold times or annoying emails with customer service. Rocket Money does all the work for you. Rocket Money can even negotiate to lower your bills for you by up to 20%. All you have to do is take a picture of your bill, and Rocket Money takes care of the rest. Rocket Money also lets you monitor all your expenses in one place, recommends custom budgets based on your past spending, and they'll even send you notifications when you've reached your spending limits. With over 3 million users and counting, Rocket Money customers have saved an average of $720 a year. Stop wasting money on things you don't use. Cancel your unwanted subscriptions and manage your money the easy way by going to rocketmoney.com/legalaf. That's rocketmoney.com/legalaf. rocketmoney.com/legalaf. Terwilliger, who's the lawyer for Meadows, is like, well, I don't want him even being processed. It's irreparable harm. Just think of these words. It's irreparable harm for my guy, one of 19, to go stop by the Rice Street Jail in Fulton County and do fingerprinting, mugshots, and get processed. Why? And the problem that Meadows has that was pointed out by Fani Willis is, really, there's 18 other defendants, including somebody who's bigger and badder than you, as alleged, who is the former president of the United States. And he doesn't have a problem of being arraigned and mugshotted and fingerprinted. Why do you? And how is that irreparable harm? And they basically... She pulled, Fani in her filing, pulled the irreparable harm rug out from under Meadows by saying, how could it possibly be irreparable harm when under all of the case law and jurisprudence around removal, unless and until the federal judge makes the decision to take the case under his jurisdiction, every other activity in the state court case continues unabated. So that means arrest, mugshot, hearings. If Judge McAfee wants to hold a hearing on Friday about something status conference, state court, you do you unless and until the federal court makes its decision. Just because you file a notice of removal doesn't put a pin in the process in the state court. And she also reminded, not that the Judge Jones needs to be reminded because he was a district attorney himself or worked in an office like that. She said, also, you have to get, even if it moves to federal court, he has to get arrested. He has to get booked and processed. So let him get booked and processed in Georgia. What's the difference? I mean, that he'll get arrested because they think, just to round it out, Terwilliger, the lawyer for Meadows, thinks, I've got such a great argument to have the whole indictment dismissed. I'm going to stop my guy from even going into the system. And nobody else sees that but him. And I think I think a couple of things are going to happen. One, I think now that she's filed now at 3:00 right on the dot, Fani Willis with Judge Jones as required, he's going to rule later today or certainly later today, could be tomorrow morning, because she's made it clear, Ben, that unless she is stopped by the federal judge, she's issuing an arrest warrant and she's going to pick up a fugitive from justice, Mark Meadows. His notice of removal, be damned.
And she makes it clear to the federal judge that, Judge, this is a states' rights issues, right? The ultimate irony here is that people like Mark Meadows and other co-defendants who are the ones out there, states' rights, until they want a federal court to issue an injunction to stop a state-level prosecution from taking place. And just to your point, he's going to have to get booked at some point. And the level of privilege here that Meadows believes that he should be treated differently from everybody else who goes through our court system. It's matched by the arrogance in his motion to dismiss. We did another hot take on that, and his removal notice, acting like he was just engaged in normal behavior of what chief of staff do all the time. And you're infringing upon that right as me being a chief of staff to set up meetings for Donald Trump and just coordinate his schedule. And that's not what you did on January 6th. That's not what you did leading up to the insurrection. And by the way, we know already there are former, top Pence aides and former top Trump administration aides who are ready to line up to testify against Mark Meadows, perhaps at this evidentiary hearing on August 28th. And finally, I'll just say this. it's a very clear statute. Like, this isn't a complicated issue, right? The removal statute under which Mark Meadows removed the case to federal court. I mean, it just states that the filing of a notice of removal of a criminal prosecution shall not prevent the state court in which such prosecution is pending from proceeding further. It's simple. Like, it's very clear in the words. So you have all of this noise, you have this chaos that's being created, but, ultimately I think you have Judge Jones, law and order judge, who's going to get and understand this issues. The only thing that I could potentially see happening here, and this is addressed as well in the kind of exhibits and the back and forth ones that Meadows filed, and also that are addressed by Fani Willis, is, Meadows acted like he just said to Fani Willis, look, just give us one more day after the evidentiary hearing, and just give us a day. And Fani Willis is like, I've given you 2 weeks. What are you talking about? I could have got you. You could have been arrested the day after the indictment dropped. You had 2 weeks, so you don't need now 2 weeks and a day. And also, Meadows, you haven't provided any actual concrete dates in the meet and confer of when it would be good for you. And also, I'll leave everybody with this. Meadows also forced Fani Willis in the special purpose grand jury proceedings going all the way to the South Carolina Supreme Court. Meadows used every delay tactic in the special purpose grand jury proceedings to try to screw over Fani Willis, and she remembers that. And she remembers no meet and confer was ever handled with Mark Meadows' lawyers in good faith, and all of the ways they tried to block her over the course of, 18 months, 24 months before she ultimately brought this indictment before a grand jury, which then the Trump people in the MAGA world say, well, look, it took her so long to file. Look how long it took her. Well, it was because people like Mark Meadows were causing all this delay and chaos and then weaponizing it against her. So I think
on that point, Ben, she's pissed off, and she recites it in the filing that she just did at 3:00 today. She says, I had a number of phone calls and conversations, to your point, Ben, with the lawyer, and he kept asking for more time for the arrest and the surrender without giving any end in sight. And when he didn't like the response, which was, why do you need more time? And you've had 2 weeks, he then run off and filed the motion for an injunction to stop the Fani Willis as a district attorney from arresting the client. So she is not. If you're going to deal with her, you better deal with her in good faith. You better just say to her, look, I don't want you to be sandbagged. We're going to file a notice of removal. We're going to ask, if you don't give us more time on the arrest, we're going to ask to have you enjoined. And we're going to ask for an evidentiary hearing, or on its face that the thing, just tell her. I mean, I've never seen a group of people who are more willing to try, even in their interactions with the prosecutor after indictment, to mislead them than this group.
Well, it's the same group that supported insurrection trying to overthrow our democracy, who are involved in a RICO criminal enterprise. So birds of a fascist feather flock with Donald Trump together. Go check out MeidasTouch.com for all the breaking news, our new homepage for all things MeidasTouch. Make sure to subscribe to the Legal AF podcast wherever audio podcasts are available and downloadable. See you next time on Legal AF.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.